Meaning and purpose of writs. Wharton, in his law lexicon, defines progressive prerogative writs as processes issued upon extraordinary occasion on proper cause shown. Lord Halsbury, in his Law of England, calls them extraordinary remedies, which are issued upon shown in cases where the ordinary legal remedies are inapplicable or inadequate. Inapplicable or inadequate. Writs are a feature of the Anglo-American system of jurisprudence. The word writ has been used in the sense of a written document under the seal of the court issued to a person or authority, including government, in appropriate cases, commanding them or any of them to do or forbear from doing some act. Hidayatullah Justice in Bhilal versus Additional Deputy Commissioner Akola EIR 1953 Nag 19. There are two kinds of writs: prerogative writ and original or judicial writs. The original or judicial writs commence between party and they issue as of courts. The prerogative writs are exceptional processes which issue only upon proper cause shown. As the prefix prerogative suggests, they do not originate from the enacted or common law, but issue from the sovereign rights of the king as fountainhead of justice. The prerogative writs are ancient remedial process of an extraordinary nature which have from the earliest time issued from the court of king's bench, in which the sovereign was always present in compensation of law. The jurisdiction to issue such writ was later on extended to the High Court of Justice under the Supreme Court of Judicature Act 1925 in England. What writs can be issued? Under Article 32 and 226 of the Constitution of India confers upon the Supreme Court, the High Court, respectively, the power to issue direction, order or writ, including writ in the nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari, for enforcement of the fundamental right, and in case of fertilizer corporation, Kamgar Union versus Fertilizer Corporation AIR 1931 SC 344. The importance of Article 32 has been explained in the following words. The Judicial Supreme Court has been characterized as an important integral part of the basic structure of the Constitution, as it is meaningless to confer fundamental rights without providing any effective machinery and remedy for their enforcement, if and when they are violated. India being a republic, there is no such thing as the prerogative of the crown. The Constitution of India nevertheless armed the Supreme Court and the High Court with powers to issue exceptional processes, which we may not call prerogative writs, but which are of the same nature and scope as such writs. That is, which are, in the words of Lord Halsbury, extraordinary remedies intended to be applied in exceptional cases in which the original legal remedies are inadequate. Having regard to the language of Article 32 and 226, the powers of the Supreme Court and the High Courts are not confined to the issue of such writs, but cover a wider field. They may issue any other order, direction, or writs whichever be deemed appropriate by them. In Rashid Ahmad versus Municipal Board, Kairana AR 1950, Supreme Court 163, the Supreme Court said the power given to the court under Article 32 are much wider and not confined to the issue of 5 prerogative writs only. In Chiranji Lal versus Union of India 1951, Supreme Court 41, Mukherjee, Justice of the Supreme Court, observed that Article 32 of the Constitution gives us very wide jurisdiction in the matter of framing our writ to the suit the exigencies of particular cases. At the same time, the right to get the relief under Article 32 is guaranteed under Article 32 Clause 1, whereas Article 226 does not carry such rights. The authority of the Supreme Court extends to the whole of territory of India, while that of High Court is limited to the territorial jurisdiction of the state. Number 1, habeas corpus. The literal meaning of habeas corpus is you may have the body. The writ of habeas corpus is a writ for securing the liberty of person where such liberty is wrongly taken away. It is an effective means of immediate release from unlawful detention, whether in person or in private custody. The writ consists of a command from the court of the production of the person detained or imprisoned, and through this writ, the court may make an inquiry into the cause of imprisonment. If there is no legal jurisdiction for detention, the person detained is ordered to be released. Who can apply? The application for habeas corpus can be made by either the prisoner himself or by any other person on his behalf. By any other person on the behalf of the accused or the prisoner or the detainee. ठीक है. The person detained. The Supreme Court in Sunil Batra versus Delhi Administration AIR 1980 Supreme Court 1579 observed that the technicalities and the legal necessities are no impediment. The court entertaining given an informal communication as a proceeding for habeas corpus. The Supreme Court has now considerably widened the scope of locus standi. Now, any person who is substantially interested in the affairs of any class of person who by reason of poverty or any other cause are unable to approach the court for the issue of the writ. When the writ can be issued, number one, the application for or the person for whom the application is made must be in custody. Number two, the application of habeas corpus ordinarily should be by the husband or wife or father or son of the detainee. Sheila Barse versus State of Maharashtra, AR 1982, Supreme Court 1473. All the formalities relating to arrest and detention was based on mala fights. Example, long delay in communication of ground of arrest. Number 4, the order of arrest must be defective in substance. Number 5, vague and indefinite grounds of detention can also be one of the good grounds for getting a writ of habeas corpus issued. Number 6, order of detention is tainted with irregularity. The writ of habeas corpus cannot be issued in following condition. Number 1, if the application is made to High Court and the place where the person is detained is outside the jurisdiction limit of the High Court. Number 2, when during the pendency of writ petition, the person in question is released. Number 3, when detention is in execution of any sentence or indictment of a criminal charge. Number 4, when a person is detained under a preventive detention law. Number 4, mandamus. Lord Halsbury in his Law of England described the writ of mandamus as follows. The writ of mandamus is a high prerogative writ of a most extensive remedial nature and is in the form of command issuing from the High Court of Justice directed to any person, corporation or inferior court, requiring him or them to do some particular things therein specified which appertains to his office or their office as and is in the nature of public duty. In mandamus, there may be command to do a particular thing or to abstain from doing a particular thing. That is, the command may be either positive or negative. It lies in the respect of a legal right and a legal duty, but not in respect of rights and duties of a purely moral character. Where there is no duty but only a power to do a thing, mandamus will not lie to enforce the exercise of the power unless the power is coupled with a duty to exercise it. There must be a duty in respect to the power. Power must be coupled with the duty. So to do a particular thing or not to do a particular thing. This is mandamus. Lord Mansfield says that whenever there is a right to execute an office, perform a service or exercise a franchise, more especially if it is in a matter of public concern or attended with profit, and a person is kept out of possession or dispossessed of such right and has no specific legal remedy, the court ought to assist by a mandamus up to reason of justice as the writ expenses and upon reason of public policy to preserve peace, order and good government. When the writ will be granted, the writ of mandamus is granted to a person whose right has been violated if the following conditions are fulfilled. Number 1, the petitioner has a legal right. Number 2, that legal right has been violated. Number 3, that the reason of violation was the non-performance of the corresponding duty by the public authority. Number 4, that the petitioner has demanded the performance of that legal duty by that public authority. The authority has refused to act. Number 5, the duty sought to be enforced most of a public nature, that is created by some statute and not of a private nature. Created by some statute and not of a private nature. When it will not lie, the writ of mandamus do not lie in the following circumstances. When the duty is to do ministerial work. Number 2, when the duty is merely discretionary, that means it is based on the discretion, on the will of the person, then that kind of duty mandamus cannot lie. To enforce contractual obligation, mandamus cannot lie to enforce contractual obligation. In Punjab Engineering College versus Sanjay Gulati, AIR 1983, Supreme Court 580, the Supreme Court observed that held that college authority authorities were under mandatory duty to admit students to educational institutions. No student can be denied admission on extraneous ground by overlooking norms set down by rules and regulations. If it is done, the Supreme Court can order the authority concerned to set to wrong right by admitting the student left out wrongly. Number 3, prohibition. Writ of prohibition is a judicial writ issued by the court of superior jurisdiction directing to an inferior court for the purpose of preventing the inferior court for usurping a jurisdiction with which it is not legally vested, and to compel courts empowered and trusted with judicial duty to keep within the limits of their jurisdiction. Dost Muhammad Khan versus Hyderabad government, AIR 1953, Hyderabad 222. Thus, the writ of prohibition lie only against the judicial and quasi-judicial authorities. Writ of prohibition lie against the judicial and quasi-judicial authority. A.G. Gubert versus High Court, Allahabad, AIR 1953, all 68. Thus, prohibition may be issued, number 1, for both excess of jurisdiction and absence of jurisdiction, violation of natural justice, fraud, violation of law of the land. Then only prohibition can be issued. Number 2, to a quasi-judicial or judicial body which is inferior than the issuing authority, to the lower authority from the higher authority. Existence of an alternative remedy is no bar to the issue of prohibition. If there is an alternative way also, in order to enforce, in order to correct the mistake, correct the conditions, or correct the thing which can be corrected from prohibition, then also prohibition can be issued. Alternative remedy cannot bar the issue of prohibition. Distinction between prohibition and certiorari, according to decision of Hari Vishnu versus Ahmad Ishaq, AIR 1955, Supreme Court 233, there are following point of distinction between prohibition and certiorari. Number 1, certiorari is substantially concerned with jurisdictional defects, whereas prohibition is only concerned with matter of jurisdictional defect. Certiorari is substantially concerned with jurisdictional defect, whereas prohibition is mainly concerned with, wholly concerned with, entirely concerned with matter of jurisdictional defect. Number 2, the effect of interference start working at different stages in these two writs. Interference through the writ of certiorari take place after the order has been passed by the court or tribunal, but in the case of prohibition, interference comes into operation only when the inferior court or tribunal has proceeding pending before it. If there is a proceeding pending, then prohibition applies. If the court has made the decision, conducted the decision, finally decided the case, thereafter certiorari can be issued. The effect of interference through the writ of certiorari takes place after the order has been passed by the court or tribunal, but in the case of prohibition, interference comes into operation only when the inferior court, that means the lower court, tribunal has proceeding pending before it. Number 3, the writ of prohibition is meant to prohibit a court or tribunal from exercising its jurisdiction where it has either exceeded from granted one or has no jurisdiction. But in case of certiorari, the writ is asked for getting an order quashed as it was made in lack of jurisdiction. Certiorari is command or order by the superior court to inferior court or tribunal to transmit a record or cause or matter pending before them to the superior court, not to proceed with the case which is not within its jurisdiction, and also to quash any order made by the court in such a case. If the order of inferior case is found to be without jurisdiction or against the principle of natural justice, it will be quashed. In Champalal versus Commissioner of Income Tax, AIR 1970, Supreme Court 645, it was held that a petition of a writ of certiorari may lie to the High Court where the order is on the face of it erroneous or raise question of jurisdiction of infringement or violation of fundamental right of the petitioner. Who may apply? Any person whose legal right has been violated can apply for the issue of this writ. Any person may, on behalf of a group of person or society or person at large. Grounds on which the writ is issued. The following condition must be fulfilled before a writ of certiorari can be issued. Number 1, the act, order or judgment in respect of which the writ is sought to be issued should be the act, order or judgment of a lower court or statutory body exercising judicial or quasi-judicial function. Judicial or quasi-judicial function. Lower court. Number 2, such court or body must have acted in absence or in excess of the jurisdiction vested in it the principle of natural justice so as to render as such act, order or judgment invalid. Number 4, when there is an error apparent on the face of the record. There is an error on the face of the record. In case of Gujarat Steel Tubes versus its Mazdoor Sabha AR 1980 Supreme Court 1896 Supreme Court explained the meaning of the phrase error apparent on the face of the record. It was held that every order cannot be correctly corrected merely because it is wrong. Every order cannot be corrected only it is wrong. It can be quashed only when if it is vitiated by the fundamental flaw of gross miscarriage of justice, absence of legal evidence, perverse misreading of fact, serious error of law on the face of the order, jurisdictional failure, and the like. When the order shall be quashed, when it is vitiated by fundamental flaw of gross miscarriage of justice, absence of legal evidence, miscarriage of misleading of facts, serious error of law on the face of the order, jurisdictional failure, and the like. In Harbans Lal versus Jagmohan Saran AIR 1986 Supreme Court 302, it has been held that the writ of certiorari is issued only if the order of the inferior, that means the junior court, lower court, or subordinate court suffers from the error of jurisdiction, or from breach of principle of natural justice. There is a violation of natural justice principle. The person must be heard, right to heard. This kind of natural justice has been violated. Then, or if vitiated by an apparent error of law, there is an apparent error of law, then writ of certiorari is issued only if the inferior court suffers from the error of jurisdiction, from breach of natural justice principle of natural justice, vitiated by an apparent error of law. The ground mentioned above for quashing the order or self-explanatory of the term error on the face of the record. Quo warranto. So, by issuing the writ of quo warranto, the court seeks from the person to whom it is issued information as to warrant or authority by which the said person supports his right to an office, franchise, or liberty. It lies against a person who claims an office, franchise, or liberty with respect to which information is sought, so that such person's right to the same may be determined in the light of the authority or warranto cited by such person in support of thereof. That means by what authority a person has been claiming the office. For that purpose, quo warranto, writ of quo warranto can be issued, seeking from the person to whom it is issued information as to authority. By what authority? By authority which support your right to claim the office. Okay, so it lies against a person who claims an office, franchise, or liberty with respect to which information is sought, so that such person's right to the same may be determined in light of the authority or warrant cited by such person in support thereof. The writ of quo warranto cannot be issued unless the is in actual possession of the office and exercise the office. R versus Green 2QB 260. Writ of quo warranto essential condition is the person to whom the quo warranto has been issued must hold the office. The office must be in his possession at the time of issuing the quo warranto. A motion of a writ of quo warranto can be made at the instance of the private person, although he is not personally aggrieved or interested in the matter. That means locus standard principle has been extended in issuing the quo warranto principle. That means the aggrieved person cannot be interested in the matter. If a private person is there who has no interest over the post to which the person is claiming the office, he can also issue the writ of. He can also make a petition to the High Court to issue the writ of certiorari or to the Supreme Court. The motion does not require the intervention of the government or any other public authority. This type of writ is a discretionary remedy and it's not issued as a matter of course, but only after the conduct and motive of the petitioner is inquired. That means motive must be inquired of the petitioner. DC Jain versus University of Jodhpur, AIR 1977, Raj 89, Rajasthan's case. When the writ can be issued, the writ of certiorari can be issued when there is a illegal claiming of public office of an unauthorized person, illegal usurpation of the public office by an unauthorized person. Number two, the public office is of substantial nature. It's a substantive nature. The remedy under this writ can only be granted when the office in question is of public nature and not of private nature. If it is a public office, then only certiorari writ can be issued by the court. Public office is that which is created by statute of constitution. The duties to be performed are of public nature. The office must be one which is permanent in the sense of not being terminable at pleasure. Number three, the person proceeded against has been in actual possession and in use of the particular office in question. That's all about this session of writs. There are 5 writs which I've discussed in the video. If you find it useful, like, subscribe my YouTube channel for more such legal content.